Good afternoon. Chris Gantt-Sorenson here with Haynsworth, Sinkler Boyd. We are excited to have you. Today we'll be talking about the FMLA and the ADA and how they interact, and we'll also be covering a few other areas. I will tell you that the way we picked this topic was when you completed the surveys after one of our webinars. We asked, what would you like to hear about? And this was one of the things that you wrote about, and several of you suggested it, so I picked it, and that's why we're talking about it. So be sure to fill those out so that we can talk to you about things you want to hear. So popping right along, keep in mind, we are a full-service firm in a number of locations throughout South Carolina and also in North Carolina. We have a location in Raleigh, a very cool office, and lots of attorneys. We can do everything. If you have any questions or any comments that you'd like to make, just drop them in the chat. Brittany Hill, as usual, from marketing is here helping me. And if I'm missing them, she'll alert me to them. I'll certainly be checking those. Anything that we're not able to get to during the presentation, because we have a lot to cover today, I'm glad to talk to you about afterwards. So don't worry about reaching out to me. Brittany will send you what you need for your credits. Make sure that she knows what type of credits you need. And with that, let's get started. So this is the question I get the most from people who have been human resource professionals for years. And the reason it's so difficult is because neither of these laws, FMLA or ADA, are applied in the same way every time. And that's particularly true of ADA. And the other thing is they both work with each other to provide different benefits, different federal relief that all employees are entitled to. Assuming you're qualified by the number of employees you have to comply with these laws, but they operate differently. And so this is an area that's difficult to maneuver. And I also see a number of unintentional errors associated, compliance errors associated with these two areas. We're also going to talk about how these two laws, FMLA and ADA, interact with workers' comp and some of the more recent pregnancy acts, which have provided new benefits in addition to ones that already existed. Too bad we can't cover every area of law that these interact with. Any sort of leave that your employee is taking could be implicated under these laws. So keep that in mind, and don't forget to analyze any leave request under FMLA and then ADA. So what we will talk about specifically is how each law is applied as far as coverage, eligibility laws, where they're similar, where they're different, the length of leave that's required, medical documentation, how you deal with restricted duty or light duty, return to work certification, benefits while on leave, and then reinstatement. It's important to note in regards to the FMLA, just a reminder that this is federal law that gives eligible employees at certain organizations unpaid job protected leave for certain medical conditions or to care for certain loved ones with medical conditions. And the key words in here are eligible and certain and job protected and certain again. And so eligible employees are employees who have worked a certain amount of hours for a certain number of years and who work in a location where there is a certain number of employees at the location within a 75-mile radius. Certain organizations mean employers who are employing 50 or more employees. And certain medical conditions, it's serious health conditions for the employee or the employee's specific loved ones, and it defines loved ones. Or in the case of any sort of armed services, military exigency services, that applies as well. And then job protected also has significance because you have to return an employee who's been on FMLA leave to their job or a job that is substantially the same or similar in every aspect. Next slide. The ADA refresher. The ADA applies to employers who employ 15 or more employees, and it applies to those employees that are disabled. In certain instances, it also applies when an employee is associated with someone who's disabled, but that's going to be in regards to benefits. In regards to leave and job accommodation, that requires the employee, so it applies to the employee themselves as to their disability. Disability is not necessarily a serious health condition. Although it is broadly interpreted, it's typically interpreted as a condition that maintains for 6 months or more and impacts major life functions. You have to provide reasonable accommodations, which means that you can analyze those as whether or not they are reasonable, are they documented, and is it causing undue hardship. But you also have to provide leave as an accommodation. And that was some guidance that the EEOC issued in 2016 and made the ADA leave accommodation a much broader area. And frankly, it's very difficult for employers to implement. So the other thing to remember with ADA is if we're doing light duty there, we might have to do it with ADA. So this is a very complicated body of law, and I find the most infuriating for employers who are looking for some definite guidelines, some boundaries that they can operate their business under, something that can apply generally to all employees. And any policy that you have that you want to apply generally to all employees is going to violate the ADA. Because the whole thing about the ADA, it's a case-by-case basis. And the EEOC specifically said the ADA extends beyond max leave policies. So I have employers who'll say, we're going to write a 6-month total leave policy or whatever time period, a 12-month total leave policy. And after that, if you can't come back, it's it. The EEOC says that the American with Disabilities Act specifically requires you to offer ADA leaves and accommodation past those time periods. So we'll talk about that a little bit too, but it's important to keep it in mind. Next slide. All right, so I told you we'd talk about the differences between the FMLA and the ADA, and here's a chart, and y'all will all get these slides, but you can see already some of the differences I've touched on. The FMLA is on your left-hand side. The ADA is on your right-hand side. 50 or more employees versus 15. The differences as far as eligibility, an employee has to have been employed 12 months within the last 7 years in order to be eligible for FMLA. And they also have to have worked 1,250 hours from the date looking back for 1 year. So 1,250 hours in the last year. And if you are looking at your calendar date and they've asked for leave, you can look from that date all the way back to the year before. Someone says, should you offer an ADA certification to employees out on workers' comp if they are returning? We'll get to that, and remind me if we don't, Brittany, to discuss that when we get to the workers' comp slide. Thank you for your question. Serious health condition, that is not necessarily a disability. A serious health condition is what it sounds like, and it is specifically defined under the FMLA, as a chronic condition that you get treatment for 2 or more times a year, and that the 2 or more times a year is supposed to be liberally construed, or if you're overnight in hospital, or if you're out for more than 3 days for a serious health condition. Something that's important to keep in mind is benefits have to be maintained at the same level as that they were in. The only way you can recover for employees not paying their portion of healthcare premiums while they're out is if they don't return and aren't disabled from being able to return, right? So in other words, you've got to keep up their benefits. You can tell them, hey, you need to be paying your premiums, but you need to keep their benefits up while they're gone and then recoup what you can afterwards in regards to their portion of the premium. Another thing important is that when someone's been granted FMLA, you can't ask them how they're doing throughout and giving status updates. They've been granted FMLA. If it's for a block of time, let's say it's for the whole FMLA period, they need this much time to recover. Don't ask them to give you updates. If it's intermittent, it's every 1 year. If they haven't been granted a block of time, full FMLA, then it's no more than every 30 days. And again, I'd be really careful asking if you know that it was never intended for them to be able to return within a 30-day period. Let's say it's a 40-day period. Don't ask at day 30, knowing that 40 was what the doctor approved. Intermittent FMLA is tricky because it's based upon the hours worked, and that's another thing to remember. If your employee has a 40-hour work week, then they're entitled to 480 hours of intermittent FMLA a year. They have a 50-hour work week, you need to do the 12 weeks times 50 hours for a more accurate intermittent leave qualification. And conversely, if they have a 36-hour week instead of a 40, then again, you could use that instead. So ADA, popping over to that, It applies from the very beginning of employment. There are no requirements if you've begun employment or even if you're being interviewed for employment, the ADA applies. Like we've talked about, it requires a disability, but after 2009, the ADA has defined disability so broad that it'd be rare that someone who has a condition for which they seek treatment on a regular basis, so like a chronic illness, or that has a condition, is not going to be considered disabled. That's a very broad definition now. And your pay and your benefits are tied to your position. So if we have someone who's out and it's an undue hardship for us to continue granting them leave under a specific position, we have to offer them any other available position for which they're qualified. We don't have to maintain their job for them. I know, though, that the EEOC has specifically interpreted the ADA to require us to maintain somebody's job for them for a reasonable period of time, which is new. That is, along with that guidance that they were talking about leave and accommodation in 2016, that is new. And so if an employer can do it without undue hardship, the EEOC doesn't expect the employer to keep the job open. But it is not the same requirement, the same level of legislative requirement as the FMLA is. And it's a case-by-case basis. It's dicey stuff. And this is the stuff where we recommend you get counsel, whether it's us or somebody else. This is where you need to be talking to an employment lawyer. You can ask for updates on these for every 7 days, as long as it's appropriate in the situation. If you have someone whose doctor has said they need 12 days, so we probably won't ask for every 7 days. In that situation, we'll say at day 10, hey, give us an update. We're looking forward to you returning. Let us know if there's been any change. The ADA requires you to grant leave when no other leave is available. All other leave has been exhausted under every policy you have, and there's no leave left. A lot of employers make the mistake of thinking, okay, 12 weeks of FMLA leave, they cannot return to work, they're fired. We have to let them go because they can't return to work. That will violate the ADA. Any other leave that you have that you did not apply will also help to extend their leave period. This is why I recommend that ADA leave, if you cannot run FMLA leave concurrently with, for instance, workers' comp leave, and the employee doesn't qualify, then you make sure that whatever you're doing, whatever leave you have, you can run it concurrently with the other leave, the workers' compensation leave, so that when they're in at the outset of any leave that you have in a policy, at that point, you're only considering ADA leave. You're not having to deal with any other leave policies that you have out there that might apply. And again, the hardest thing to administer as an employer is there is no set time to the length of leave an employee can have as accommodation. So I'm getting a bunch of questions and I'm going to answer as many of them as I can right now, and then we'll pop on to the next slide. But for now, Brittany, leave that slide up. So y'all can see the questions. Trina asks, should you offer ADA certification to employees out on workers' comp if they are returning to work with restrictions? In a situation with workers' comp, if someone's returning to work with restrictions, they've just come back on light duty. They don't really need to go through the ADA certification or the ADA leave policy. So if I'm understanding your question, we've got someone who's coming back to work, they're returning on light duty. ADA leave doesn't even apply here. ADA leave is additional leave, right? Now, when we get to the ADA part, though, that is one thing I recommend you as employers to do, is that consider what sort of work the employee can do. And then maybe instead of granting leave, you have them come back and they work light duty. There's issues with that. Once you grant light duty for one, you got to grant light duty for all. But you can have them come back and work rather than take leave. Nancy McCartney asks, what if you have someone on intermittent leave and their performance is not to standard? They're missing deadlines, not completing work timely, discipline, and/or can you remove intermittent status? So Nancy is asking, can you require an employee to take more leave than they want to take? And that is a very dicey question, because the regulations say specifically you can never make an employee take more FMLA leave than they need. There are some remedies available to employers whose employee is not able to perform sufficiently on intermittent leave. And we are going to talk about those when we talk about those in the context of the Department of Labor's opinion letter. But those guidances from the regulations still leave gaps, Nancy. And so this is tough stuff. And I would call this a minefield that you're playing chess through. And it's one of those where it'd be good to talk to counsel, just, very qualified HR consultant that you are, just to have somebody else to bounce it off of. Allison asked, my employer has a note in the policy that says an employee must follow call-out procedure while on FMLA. Should that be removed? My answer is yes. I would require that to be removed. Now, I'm going to tell you, generally, you have attendance policies and notification policies that employees must follow when they're on leave, no matter what kind of leave. But on FMLA leave, if the employer knows this employee is not showing up for 40 days, then there's no reason to require the call-out. And that should obviously be communicated to the supervisor as well. In that situation, I think I'd be concerned about some sort of FMLA interference claim and possibly an ADA disability harassment claim, and maybe even an FMLA and ADA retaliation claim. That's what I'd be concerned about in that scenario. All right, is that leave paid or unpaid leave? All of these leaves that I'm talking about are unpaid. I think situations where employers get themselves, because it's confusing, and a little bit of trouble is when they start tying, okay, paid leave dovetails with these federal rights. They do not. These are federal rights that have nothing to do with whether or not they're paid, which means, and a lot of times I see this, a lot of people will say, oh, well, they're out of PTO, so no more leave left. No, they have federal leave rights. They may not have any paid leave left, but they still have these rights. All right. Whew. I think I've answered the questions. So I'm going to close my chat box. Oh, I've got some Q&As over here. Couple more. Okay. Paul Hilton asked, if an employee has less than 15 employees, to breathe a little bit here, can the employer have a policy which states that if an employee is out of work for medical leave more than 30 days, that employee will be terminated? No, I wouldn't recommend it. I just wouldn't recommend it, but I have to think about that. You do have less than 15, so you don't have to worry about the ADA. You certainly don't have to worry about the FMLA. And you said not associated with workers' comp, which means there's no workers' compensation retaliation claim. Maybe. I have to think about that one, Paul. That's a great question. I can't find anything wrong with it right now, but I'm in the middle of giving a speech and I'm a little out of breath and I may think of something later. Amanda Fallow, what if you have asked their physician certifications multiple times? What is a reasonable time limit? Here's what I say. If you ask somebody for a certification, you give them 7 days turnaround time, and you tell them they have to get it in and it's their obligation. One of the two things that the EEOC specifically said in its guidance in 2016 is there were two exceptions to this ADA leave policy. And one of them is if the employee is not getting their medical information that justifies the request for the accommodation to you in a timely fashion, and they're not being helpful. So I say give them 7. If they don't get it to you in 7, maybe give them a few more. You want to be able to show always on paper that you're trying to work with them. And by the way, you heard I said paper. Be communicating with them in writing, even if you're talking to them verbally. You make sure you're backing this up with email or mail so that you have proof of it later. But in a situation where they're not helping you get the paperwork, and this says it was due on 2/23, and if you've not followed up with them, which I would follow up with somebody as soon as they've not gotten something to you, so that you can show you gave them another chance, then they're not helping, and it might be time to end the employment. Lakeitha Bell, if I have someone eligible for ADA, the doctor sent over new restrictions, do we complete the entire ADA paperwork? That question is confusing to me, Lakeitha. I'm going to ask you to describe it or explain it a little bit better, and then I will definitely answer it to the best of my ability. All right, Brittany, let's hit the next slide. Similarities. Both laws have unpaid leave. Both laws say that no employee can be required to take more leave than is needed. Both laws say that you do not have to require them to take leave if their job can be modified. Now, if someone's job can be modified, you're more likely dealing with the ADA rather than the FMLA. Both laws permit for jobs to be changed. The ADA, you're typically modifying duties. That is not necessarily an FMLA requirement. But in both laws, you are required to reduce hours if you can do so, and the employee can still do the essential functions of the job. Both laws require you to consider alternative positions. Only the FMLA requires you to pay someone the same amount of money, no matter what position you put them in. the ADA will permit you to pay them the salary associated with the position you moved them to. Both laws permit you, you're not required to, but permit you to have return to work certifications. I would recommend that you have return to work certification for any employee who's out on any form of leave that has anything to do with any medical, psychological, injury, illness, condition. I just think that's wise from a number of standpoints. And the other thing is I'm wanting you to do this consistently for all types of leave, no matter what they are. Both laws require you to return the employee to their former positions. The exception, of course, under the ADA is if it's undue hardship, but you have no exception under the FMLA unless this is a key employee. Key employee is specifically defined in the FMLA, and so before you decide you're going to implement the key employee exception to somebody being able to return to work, this is an area that you need to review the regulations very carefully. And again, I recommend get counsel. Next slide. I had to slow down talking, y'all. I was getting dizzy. I was talking so fast trying to answer y'all's questions. All right, the medical documentation. So the ADA, you're only allowed to make medical inquiries in an ADA situation when someone is asking you for an accommodation or you think there is a direct threat situation. Otherwise, you do not need to be talking to them about medical. In that situation too, all you're wanting to know is whether this employee is able to do the essential functions of the job with or without the accommodation. And so that is something that you cannot guess about, nor are you a doctor. And you want to give the employee an opportunity to do that with their own doctor. Or if it's a direct threat situation and they don't have a doctor, then you can send them to your doctor. Direct threat is dicey. You got to be careful when you're using that. So FMLA, there's a specific medical certification form. If you don't use the forms that the Department of Labor created for FMLA, then you should. First of all, they're free. I know that some companies provide services to create them for you, but these are free. Second of all, the Department of Labor is who determines whether or not you violated the FMLA. So it makes sense to use the forms that they created for the purpose of complying with the FMLA. You can find these forms on dol.gov and their A and Z index. Hit FMLA and the forms will be there. If you want a doctor to indicate whether or not the employee is able to return to work, you have to click a special place on the form when you designate the leave, and you need to attach your job description to the designation notice. If you don't do that, then you cannot require that upon the return. There are only two instances where you can question the information you're getting back in FMLA, and it is one for clarification and the other for authentication. And I'm going to talk about those on the slides next because there are actually regulations which define those. So we don't apply our own lay understanding of those words. We instead follow the regulations. And then employers, if they don't agree with what the employee's doctor has said, can seek second and third opinions. And those would be always at the expense of the employer. Next slide. All right, so authentication and clarification. These are specific regulations. Authentication means we ask the healthcare provider, is this your signature? Did you complete this? That's it. Clarification means that we ask the provider to help us understand the handwriting or to understand the meaning of a response. In both situations, you are required to talk to the employee first and give them an opportunity to provide you with updated paperwork before you do this. You never talk to the provider, ever. You call the provider's office. I ideally would say you put this note in a fax cover form of, is this the doctor's signature? Did y'all complete this? Or who signed this? And what does this mean? But you got to be careful about what does this mean, because you can't be asking for more information than's there. You're only asking for an understanding of the response there. You cannot ask an employee's medical provider any sort of questions about the employee's medical condition ever. Next slide. All right, so if you doubt certification, you can get second opinions. On the second one, you can choose the provider. It should not be one you use regularly or you have on contract, because that provider's ability to give an unbiased opinion will be challenged in court. If it differs from the certification, the employee then has an opportunity to ask for, thank you, Perry. I'm glad Perry's on and answering some of these. If the employee does not agree with the second opinion, then the employee can request a third opinion, and the employer must pay for that as well. During the process, make sure you're granting provisional leave. And as I indicated before, they've got to be reimbursed for their out-of-pocket expenses. You're going to be paying the providers directly. And frankly, you got to pay them for their travel expenses to and from the appointments. Next slide. Okay, light duty. This is tough. If you are not offering light duty outside of the workers' compensation context, before you decide to do so in any other context, make sure you're stepping into that willingly, because once you open the door for any sort of light duty, it has to be opened everywhere. For pregnancy, for ADA, for any sort of medical, psychological leave. Once you've granted light duty, it'll be hard for you to explain as an employer why it's offered to some employees but not others. And even with workers' compensation, the fact that you have it for comp, although there's some law that would suggest that that's a separate bucket and it does not apply to bind the employer to light duty elsewhere, that is not solidified substantially enough to where I would be comfortable recommending that you don't grant it if you're not also granting it in light duty, or at least it'd be worth something to consider before you decided you're going to deny it. FMLA, if the employee wants to take intermittent leave, and if that looks like light duty, an employer has to consider it and grant it. But if you have a situation where the light duty means they can't perform the job the way you think it should be, then you can switch them to an alternative position. Next slide. All right, we talked about return to work certification. I think I've already addressed that. I think you should do it. You need to tell the employee they have to do it. You need to attach the job description, and on the FMLA form, the designation, you need to click it. There's a little box you have to click and attach the job description in, or you won't get to ask for it when they're able to return. Next slide. Benefits while on leave, we talked about that. There's no specific requirement under the ADA, but it's best to require them to do it. This is unpaid leave, right? So they've got to pay their premiums. You can alert them that, under the grace period, time periods applicable in your healthcare plan, if they don't pay their portion of the premium, it may be canceled, and then you need to follow the plan's notification requirements. In that scenario, if they're not paying the premium, you could cancel it. FMLA, you have to continue the coverage, and typically it's just the best practice to continue it throughout the FMLA, even if they're not paying premiums, and then recoup those premiums when they return. Remember too, though, if you've got any sort of paid leave benefit that is running concurrently with any of these unpaid leaves, you just take the premiums as you have been out of their pay. Next slide. ADA, very broad application. I talked about that when the ADA's 2009 amendments came out. I was saying we're all disabled now. I mean, in truth, we really are. Disabilities are broadly defined, and then they're even further conditioned on major life activities, which every single thing you can think of is named as a major life activity. And leave is required, assuming a modification of the job is not permissible. It's complicated. There's a ton of EEOC guidance on it, but the short of it is it's a case-by-case basis, and you need to analyze it carefully. So for leave, you're considering, okay, first 2 weeks, okay, another 2 weeks, maybe another 2 weeks. There's some things you can do to protect yourself during this time, but it is ripe for leave abuse. Next slide. So the EEOC has specifically said the ADA requires employers to change the way things are customarily done. And while that makes a lot of sense, it's very hard in its application because you're used to doing things a certain way. You're very, very busy, and you're applying all of the rules that have been set down in the policies. The ADA, so if the ADA is implicated, this is an area where you are required to break from how you do things and come up with a different way and be creative. Although it says equal access in the law, equal access is what's required. the way you read the ADA leave and accommodation provisions, particularly in the guidance that was issued, it sounds like it's actually greater than equal access. And that is because whatever leave you have under any leave policy, the ADA always requires you to consider additional leave if an employee is disabled. So that's greater than equal access. And if you can keep that in mind, then that'll make it easier when it has to trigger an ADA analysis. Next slide. All right. So ADA accommodation analyses, light duty, job restructuring, change the schedule, modify the schedule, put them in a different position, give them time to heal. Can't be specific on how long they need to heal. Can't be specific on how long you are keeping the job open for them. Can't be specific on how long is too long. And who is doing the work for the company now, and can this continue? And so that's an important thing to keep in regards to ADA leave accommodation in mind. Don't go ahead and say, because you don't want to deal with it the very outset of time that it's going to take. Like, okay, we can handle this for 2 months, but after that, no. My advice is, and we'll talk about how you get documentation from the provider, but my advice is you follow that time period specifically that the provider is given. Even if it's only 2 weeks, and you're like, but Chris, we could give a month. 2 weeks, and then require another follow-up within 2 weeks, and then 2 weeks. And what you're doing is you're creating a record where you're continuing to do what you can to grant leave, and you're continuing to consider it up until your undue hardship point. So instead of saying 2 months and I can't do it any longer than 2 months, when they've only asked for 2 weeks, let's play the game of the 2 weeks over and over so that you can show you were trying to work with them. It paints a better picture. And remember that anytime you're having someone do the work, undue hardship is going to factor in who's doing the work and why is this not, why is this an undue hardship if they've been doing the work? So we have to be able to explain that. Next slide. All right. So job modification or leave, I'm going to walk you through the processes of that under the ADA. And I'm going to start with both, but then I'm going to branch off and finish with job modification and then finish with leave. And this is meant to be, I mean, it's just a guidelines that I've provided. You can follow it when you're doing it. It's obviously not meant to be legal advice, but it's just a little checklist of things to think about when you're going through it. So number one, most important thing is communication. You want to be able to communicate and show that you've communicated. So if you're dealing with an employee that you're texting, or if you're talking to verbally, can you text or can you email? Most employees these days have emails. Even if they don't have a work email, they have a personal email. If they're using those formats to communicate with you and they've agreed to accept notices by email when they begin employment, then you can be communicating with them in writing that way. A lot of employers are texting with their employees. That's fine too. Make sure you're keeping screenshots of the text so that you can establish those communications later if you're called to do so. But you need to be communicating. So if you're having verbal conversations, you need to be documenting them in some way, or they're not happening when we get to the EOC. So an employee is asked for some sort of accommodation. You meet with them and you tell them, you ask them, what is it that you need? We want to help you. What is it that you need? What is the problem? And how does it impact your ability to perform your duties? And what sort of accommodation do you need? It's an opportunity for you to hear what they have in mind. A lot of times this is a very easy thing to comply with. As far as leave, you can even ask, what's the specific reason? You're allowed to ask with FMLA and ADA, what is the reason you need leave for? You don't just have to accept, even if they've already been approved for FMLA, intermittent leave, they may be taking leave for something that doesn't fall under it. So you have every right to say, now what's the basis for this leave? Why are you needing leave? And they can have to tell you what the condition is. You don't want to ask too many questions from that, but you're entitled to know that. You also, when they're asking for leave as an accommodation under the ADA, do you intend to do this sporadically, or is it going to be a block of time? And when do you think the need for leave will end? You're allowed to ask those things. Next step. If the disability is not obvious, you are allowed to ask the employee to have it verified with their provider. I'm going to recommend that you do this in all ADA situations where the disability is not obvious or where you don't already have some sort of proof that there is a disability, such as short-term disability forms that are being filled out contemporaneously with it, or FMLA. after FMLA is expired and you still have an FMLA response back that would also qualify. But otherwise, I want you to do this every time because I don't want you to be caught in a situation where you're doing it sometimes and not others. You ask the ask the employee to have the provider advise whether the employee is able to do the essential functions of their job and what their restrictions and limitations are. And you give the employee a copy of their job description to take to their provider. And that is how you certify this leave. And before you have any promise about whether you're going to grant an accommodation, you wait to hear back what comes back, because a lot of times you'll be surprised they're not able to provide documentation, or the restrictions are such that it's going to be a different type of accommodation than they requested. After the medical information comes back, and I usually say give the employee 7 or so days. Obviously that is not a hard and fast rule. If you need to do more for whatever reason, do that. Wait until that comes back. And in the meantime, if they're saying they can't work, that it's causing their disability to flare up, or they're having any medical problems, don't have them work. They should stay out while you're waiting. If they are hourly, or even if they're exempt and not doing any work, they don't have to be paid if there's no PTO. Next slide. So they come back and you've looked at the medical certification. They may have been asking for leave or, change my job. You look at the restrictions and you decide, all right, I see these restrictions. It's the employer's responsibility to decide whether or not those are going to interfere with the essential functions of the job or not. Sometimes medical providers will write down this employee is able to do the essential functions of the job. The medical provider's job is to verify the condition and tell you what the restrictions and the limitations are. It is your prerogative to decide whether or not those restrictions and limitations are going to permit them to do the essential functions of the job. And when you go through that situation and you've determined that the condition is verified and you know what the restrictions and limitations are, you meet again with the employee. We go over the employee's reasons or ideas for accommodation. And this is called the interactive process, where we talk with them about how can we resolve this, what can we do? If their idea for accommodation is not one that can be granted, you have to offer alternative ones unless there are no alternative ones. If there are no alternative ones, you have to explain why, and you have to give tangible reasons why. They can choose to turn down your alternative ones, and that is something that's on them. But you must offer alternative accommodations if you're able to do so. All of this should be documented. And if you're doing this, you really should have someone meeting with you with the employee and taking notes of the whole communication. After you reach your decision about what the accommodation is, then I'm liking that to be documented, you and the employee sign and date. Next slide. Have the supervisor there. They should be involved in this process. The supervisors should stay out of the process through the whole medical documentation part, but they should come back in when we're considering whether or not we're going to modify the job and how. Everybody signs the agreement, and then the accommodation has been granted and we move on. Or if there's no accommodation or the employee is turning down alternative accommodations, that's signed, and then you look for other positions for which the employee is able to perform, for which they are qualified that they can perform. When this happens, you're going through and seeing what are you advertising, what is open in your office or in your plant or in your location, and the ones that they're qualified for, you just go through them on the screen with them. And you ask them, what about this? What about this? What about this? Again, this is an interactive process that needs to be documented step by step. I'd like for you to have a witness present who's witnessing and also taking notes. If that employee turns down all of those, that's the documentation. And ideally, we say we offered them these positions and the employee refused, and the employee signs and you sign and the witness signs. If the employee refuses to sign, the witness can say this is what happened. And then the employee's employment is ended. Most of the time, though, it doesn't get this far. Next step. Leave is an accommodation. So we're going back to step 3. We've got our medical documentation back. We're now meeting with the employee. Is this leave an undue hardship? Because if it's not, we have to grant it. If it's an undue hardship, we have to consider specific tangible reasons as to how it's impacting business operations. And I'll go through what your undue hardship analyses are later. Another thing you can consider is, I see these restrictions. This employee wants leave. But this employee can do this job with these restrictions. We can accommodate them and have them come in and perform this job, and we can adjust some of their essential functions, but the others they can do. Or there's other work that you can do and help us out. You can't do your essential functions, but we have these other jobs and we could use your help on those. So you can offer those down. If they turn those down, it's an interesting question. I'm not going to tell you on a webinar. I think Perry's on. He would say, oh no, Chris, don't say that. I'm not going to say we can let them go if they're refusing to return to work when we see that they can, because their doctor has said by now, leave as an accommodation is reasonable because of their condition. But it is something to think about. And that is probably where I'd call counsel, because if there's work for them to do, it seems reasonable for them to come to work, and you require them to come to work unless their doctor says they can't. Maybe something would be that we write down that we send the job description of the alternative job or how we've modified this job, and we have the employee go back and indicate whether this employee still needs leave or is the employee will be able to do the essential functions with these changes. And then we talked about light duty already. Next slide. Leave as an accommodation, document it. You can also, when it's leave as an accommodation, require them to keeping you updated and alerting you as to whether or not they're going to be able to return. Make them request the extension, make them provide you with the documentation if they've asked for the extension. Go through those processes every time. Next slide. And document. If you cannot grant the leave, I explained before, just like with the modification, you need to be able to give them tangible reasons why. And then you need to always tell them, you are eligible to return here for any available position for which you're qualified when you are able to return, so keep us posted. And you want that in writing. Next slide. As I just indicated, after you've granted the leave, you continue to go through the modification process, the modification analysis, or the condition documentation for every request for additional leave that they ask for. Next slide. All right, so here are the undue hardship factors for job modification. I'm going to slide through those kind of quickly. The most important would be, obviously, how is it impacting how you're operating? Who's having to take over these jobs? If you keep a temporary staffing company on site and they cover for employees pretty regularly, you'll have a harder time saying this is a hardship. The larger you are, the more resources you have, you'll have a harder time saying this is an undue hardship. Inability to meet production, tasking, or overworking your existing personnel, those sound like undue hardship. But it's something that requires you to offer tangible, factual explanations and not just say it's an undue hardship. Next slide. The undue hardship for leave is a lot the same. The effect on coworkers, who's doing the job duties, how's it impacting our ability to meet our customers' needs. So you have these factors as you're going through analyzing, and the supervisor is saying it's a hardship, it's a hardship. Make them give you tangibles before we can proceed. Next slide. Confidentiality. These are the folks that are allowed to know what sort of disability your employee has. Supervisors and managers only in regards to how they need to know for accommodation, and then to provide first aid or if government officials ask for it. So that's important to remember, because it's a lot more constrained than a lot of employers think. Supervisors, other than what the employee shares with them, have no right to know what the employee's conditions are. And in fact, you protect supervisors and decision makers in the company by keeping this information from them, so that when there are employment decisions made, they can honestly say they didn't know what the employee's conditions were. Next slide. All right, I want to get to the opinion letter, and hopefully we'll be able to get to some of the other slides, and then I'll follow up with those questions at the end. This is an opinion letter that the Department of Labor issued February of this year, and they have not issued an opinion letter in a long time. One of the attendees today read my blog on it and had some great questions, and so I'm going to address those in the next slide. But it's a surprising position. This was an employee who normally worked an 8-hour day, has a chronic serious health condition, and says, I'm not able to work an 8-hour day anymore. The Department of Labor said the employee is entitled to an indefinite reduced schedule under the FMLA if the employee has been approved for intermittent leave by their provider. So this employee has been able to provide medical certification from their provider that says this employee is entitled to take 2 hours every single day as intermittent leave because they are not able to perform work for the 8-hour period due to the medical conditions. The Department of Labor said employers have to grant this. They have to grant it. They cannot make an employee take more leave than they need. And reduced hour leave is absolutely one of the regulations that the FMLA has promulgated. What's tough about that is, does this then change the nature of this job permanently? The Department of Labor also said that after the intermittent FMLA leave is expired, then you also have to do ADA leave as an accommodation, and an accommodation would be granting reduced schedule. In both situations, you can move them to another job, but is that a permanent change in job as well? So, next slide. I got a great question about, so the Department of Labor is just going to change how we do business. And the Department of Labor is going to insist that we restructure this job to where an 8-hour job is now a 6-hour job. So here's the help you get from the Department of Labor. And there's gaps. These are all specific from regulations. The first one, you under the FMLA, not just the ADA, may ask on the doctor for the employee, what's the employee's ability to perform the essential functions of the job? So the same ADA analysis applies here. Excuse me. If the employee cannot perform the essential functions of the job, you still have to consider moving them to an alternative position. And if there's none, you still have to give them FMLA leave. This is a situation where you would be requiring them to take full FMLA rather than the 2 hours a day, and one where I would say you need legal advice. Reduced schedule leave is specifically allotted in the regs. I've put the reg there. That's 29 CFR 825202. I note it specifically says period of time. Now, the Department of Labor specifically said period of time is indefinite in the Department of Labor's opinion letter, but the regulation specifically says for a period of time. If the Department of Labor was challenged in a court of law, I don't know how that would come down. I've not had an opportunity to perform that research, but the employer may prevail. It won't be the first time that a court has not agreed with a federal agency in regards to application of the law. So for an employer willing to challenge it, you may prevail. Other help is another regulation that says an employee who's taking intermittent leave has to schedule it in a way so as not to disrupt unduly the employer's operations. This means if there's a way to provide notification in advance of leave that's needed, you have to. A lot of intermittent leave is someone comes to work and they say, at the end of the day or 6 hours in, I don't feel well, it's because of my fill in the blank, and therefore I have to leave. And that's how intermittent leave gets dealt with, especially when the medical certification says anticipate this 2 days a week, 6 days a week, 5 days a week. But start documenting how it's disrupting your operations. And it may be time to consider a different approach, again with counsel. The alternative position that we talked about, that might be better. But again, how are you going to fill the regular position? It's a job protected leave situation that they've got to be moved back into. That's the release the Department of Labor's regulations provide. And they're the ones that wrote the regulations. We haven't researched it to see in this situation how that might be adjudicated if it's challenged in court. And I'm sure that'll also depend on what circuit you're in. But in a situation where it's impacting business operations, and if you can document that very factually, with the legal advice, it may be that you require them to take full leave. I did the math on a 40-hour week, and if I took 2 hours off of an 8-hour day, I would have used 520 intermittent hours. And a 40-hour week in a year, I'm only entitled to 480. So you've got then 40 hours to deal with the undue hardship bit, because after the FMLA leave is expired, that's when you slide to ADA. And if it's an undue hardship and you've already been documenting it, disrupting unduly business operations, then you may be able to deny it. You just need to be able to establish undue hardship. But your question was a great one, and it's a tough one because with this new opinion letter, we'll have to see how it gets fleshed out. So I'm going to go ahead and take time to answer some additional questions. How does recertification work? Literally, you're just sending you're asking them to advise from the medical provider that the employee is able to return to work. You want the medical provider to have the job description when they do this. When an employee submits the ADA medical verification forms and you suspect it's been forged, are there any limits around authenticating the paperwork with the provider's office? Yeah. All you need to do is do what you do for FMLA, which is you call the provider, you say, I'm faxing this, or you just fax it. And on the fax cover sheet, you write, was this completed by your office? Was this signed by your provider? Please advise so-and-so, and you put your email address. But yes, you can do that. Just don't talk to them and don't ask them questions about medical conditions. Typically, though, you're going to want to have the employee sign a HIPAA release for that process. If you can't do that, still, you can always send the form and say, the employee presented this, was this completed by your office? Do it in writing and have them write that back and be very, very careful. If you have an employee who is currently remote, but the employer is now requiring that all employees need to return to the office 3 days a week, if the employee provided appropriate medical documentation, could you accommodate them? I am not going to keep reading that. I'm going to say that if everybody is required to come back to work and this employee is asked for an accommodation, it's the same analysis, undue hardship. Is it an undue hardship? Is the employee able to do the essential functions of this employee's job? If not, is it an undue hardship? It's the same type of analysis you follow. And if not, then you might have to grant it. When is it inappropriate or appropriate to ask for second opinion on medical certification? When you disagree with the first one, when you disagree with the employee's provider's medical opinion. And I think this is a great question, Stephanie, because I just said we're not doctors and we're not. But so we're saving it for something that seems pretty ludicrous. And you might even consult with, if you have doctors on file, or if you've got even an on-site clinic, you might even consult with that provider to give you an advice here, but certainly don't use them as the second opinion. All right. And then Lakeitha says, she's got somebody on ADA, brought in new restrictions. Do I request that she complete all certification documents again, as she now has new restrictions? If she brought in new restrictions from the provider, and the provider, well, if she has new restrictions from the provider and you're not questioning those, you can look at those restrictions and consider whether or not she's able to do the essential functions of the job or not. That is the certification documentation, is the doctor's provider note back. So that is what we mean by certification. It's not a specific form, but instead someone is certifying that they have a disability and they have restrictions. I think I've answered all of those. I'm going to take a peek at the chat. Actually, you know what I'm going to do? I'm going to ask Brittany to save the chat for me, and I'm going to try to help with those offline and kind of wrap this up. So let's go ahead and hit the next slide. The most important thing that you can do in your workplace is train your frontline supervisors on what triggers FMLA and ADA. This is one of the areas where a lot of times human resources doesn't even know what's being said out in the field until they've gotten an EEOC charge where someone has contended disability discrimination, or an employer has brought an allegation, a supervisor or another employee has brought an allegation to the human resource provider that says so-and-so, I told him I needed leave, and he denied it and made any sort of comments about it, anything that's already happened that you're in a situation of having to undo. And so this is even true in workers' comp. You need to train your frontline supervisors, and I'm sure you do already, to alert when any sort of medical, psychological illness, injury is raised with them, to say nothing and to get you involved. That's the best advice I can give. When I go and I do training on this for employers, this is what I'm drilling into the supervisor's knowledge is HR, 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 HR. Because ultimately, the sooner we can get you involved, the sooner we get them out of it. And we're more likely to have a compliance situation if human resources is handling it. The other thing to train your supervisors on, and even some human resources professionals make this mistake, no employee is required to come and say, I need FMLA leave. I need family medical leave. Nobody is required to say that. They're not required to say, I need an ADA accommodation. All they're required to do is say, I'm having a surgery, or I have this condition, or I'm going to need to be out a few days for a medical condition, or I need to go, get some mental health treatment. I'm going to be out for a day or so, or my daughter has this situation. Any little thing like that is going to trigger it. So you need to be able to give them examples so that they understand, okay, this is when I've got to get HR involved. Next slide. Teach the supervisors to say, how can I help you? Listen to what has to be, answered, what the employee says, and then let's go get HR involved. I want to make sure that I am addressing this the right way for you to make sure you're getting the leave you want. And stay away from medical information, and then step away from it. Next slide. I have some role play analyses here for you to work with your supervisors. Those are things that I would, recommend that you cover with them. Grooming policy, skin condition, any of these, diagnosed with cancer, have new medications, any of these are things that they should be bringing it to you, and you need to follow the ADA process or possibly the FMLA process. Next slide. Human resource role. You handle everything else after that. You get the documentation. You oversee communications in regards to the accommodations. Even if the supervisor is present, you make sure everything is documented. Next slide. This is another role play example. I'm going to pop right on through. Oh, wait, no, I'm not. This is the one where we have, don't, Brittany, this is the one where we have a poll. All right, we're going to end with a poll today. Make sure you look at the slides on pregnancy. Sam is an employee who's been working with you for 12 years, and you have 250 employees. And part of his duties include carrying heavy, heavy boxes a long, long way. Sam calls in sick for 2 days. He says, I've got a sore leg. On day 3, he calls in and says, I went to my doctor and apparently have this very rare condition that impacts my leg muscles. And he says, I've got to heal. And he says, carrying those boxes might have triggered it. What laws are implicated? So now Brittany's going to pop the poll question out, and let's see your answers. Oh, I think she already popped the poll question out. That's right. I deleted mine. Brittany, do we have any answers yet back from them? All right. 84% of you said all of the above, and you're absolutely right. So see, y'all didn't even need this presentation today. You didn't even need this presentation. All right. I'm going to go ahead and answer some more of these questions. I understand that it's almost 1, and so if anybody needs to pop off, do. I really appreciate everybody attending. I'm so sorry I wasn't able to get through all the slides. If you have any questions about the remainder of the slides, please ask me. They're pretty important about pregnancy and lactation and nursing. And for now, Brittany, if we can leave it open for a little bit, I'm going to try to answer some of these questions that are in the chat box that have not been answered yet. All right. So Brian asked, what if you try to accommodate ADA leave for so long that eventually the duties of the position are sufficiently redelegated such that you no longer need the position? All right. So that's a great question. And that's true under the FMLA as well, that if you eliminate a position while somebody is on FMLA leave, and it's not because they're on FMLA leave, then that is not going to be grounds for FMLA retaliation or interference. What's tough about it is that was it eliminated because the person went on FMLA leave and it changed the position so much that it was no longer a necessary position? That is because of the FMLA leave. But if someone's not able to do the job and you had to reassign the duties in order to meet your business needs, then this is someone who's not able to, either under the FMLA or the ADA, perform the essential functions of the job. It's obviously essential functions of the job that require this to be done, and you've had to reassign them. Then this is a situation that probably needs to be dealt with sooner rather than later. If the job's getting reassigned, we need to be stepping in and protecting you legally before we get to that point, if that makes sense. And there are things that we can do, communications that we can have, where we're alerting the employee to the issue. So if it gets to the point where we're actually just eliminating the job, then and we've reassigned the duties, don't think that you'll be free from the FMLA compliance or ADA, because anytime you're reassigning duties and eliminating a job, the EEOC, the Department of Labor, and courts will all come behind that and ask, well, who's doing the duties now? And if you're pointing to people who are not disabled or who don't have medical conditions or who are younger than the person or it's just a situation that's ripe for any sort of employment law violation. So if it really is that much of an undue hardship that the job's having to be reassigned, something needs to be done sooner. We need to put them into an alternative position. We need to figure out if this is going to have to be a full FMLA situation. We need to figure out if this is undue hardship. If it's an ADA situation, we're just going to have to end employment until they're able to return. That's what I would advise in that situation. Are there any laws, Vivian asked, about authentication limitations that apply to employers regarding ADA medical documentation submitted to an employer? I mean, I think that's an interesting question. I know what you mean by authentic limitations, but if you are referring to the authentication and clarification examples from FMLA, those are not applicable. There's no law around that for the ADA, but the ADA prohibits you from talking to an employee's medical provider. An employee can give you a HIPAA release for providing specific information in regards to whether the employee's able to do the essential functions of the job or is posing a direct threat. And in that situation, again, I wouldn't have any verbal. I would always do stuff in writing. I would even consider, in rare situations, retaining your own doctor to communicate with the employee's provider. This is dicey stuff, and it's stuff where we need to be helping. I mean, us or somebody, employment lawyer. Please make sure you're using an employment lawyer for this. And documenting with you along the way, and maybe handling your written communications for you so that later, if we see them again, we're in the best place possible to defend any claim. Terry, in our company, a lot of times the employee does not want to be put on FMLA. I should fight this more than I should. You should. I'm going to tell you a horror story. And thank you, Terry, for throwing this out. One of the most egregious FMLA litigation matters I ever had was a situation where an employee, it was back in 2008 and 2009 when lots of folks were losing their job. And these were two positions that a company held. It was a national company, but those were two very top positions. And the assistant in the department that reported to the director had to go out for knee surgery. And she was very concerned that her position be eliminated by the employer because they were looking for ways to cut during the time period. And so her supervisor, thinking he was helping her out, covered for her and said, okay, don't worry about it, just go. And they didn't tell HR. And she went out and developed complications. And he did need her. They had a good bit of work they had to do. And she had assured him that she would be able to return after 2 weeks, but she wasn't. And about 6 weeks later, she was in the hospital with all sorts of medical conditions, deep vein thrombosis, etc. And he went to see her in the hospital and fussed at her and said, my goodness, why haven't you come back? This is awful. I'm not able to meet the needs. They're getting upset with us for not meeting the needs. You have to come back like you promised. She turned around. What do you think she did? She sued for FMLA interference, FMLA retaliation, a bunch of other stuff. We managed on some technicalities to get part of the case dismissed and we were able to settle it for a fraction of what it was worth. In these cases, when you end up in court, it's back wages, usually it's times about 2 or 3 years plus attorney's fees. And then it could also be punitive damages, depending on certain situations. It's very expensive. So if you take any job that you can think of that you pay annually at your company and you multiply it times 3 years, 4 years, and then you think about attorney's fees, which in this jurisdiction, anywhere from $250 to $750 of the plaintiff's attorney's fees will be approved as reasonable. And you add that number to it, that'll get everybody's attention. So in a situation like this, number one, I don't want your policy to say your FMLA policy to say an employee gets to choose whether or not they take FMLA. I don't want you to say that. I have seen some employers' policies that say that. I do not recommend it. Number two, under the law, the FMLA is the employer's to designate, is the employer's responsibility and also the prerogative. So you need to designate FMLA every single time, and you need to apply it every single time it applies. That's my advice. If offering an employee accommodation while they're on intermittent FMLA, employee was continuously late arriving to work and stated it was due to her condition. However, employee declines the accommodation. Are we still liable for terminating her over 45 late arrivals for her job? No. If someone's violating your attendance policies, then they refuse the accommodation. No. And even if it's an accommodation that they've requested, if it wasn't about attendance, being to work on time, but about some other accommodation, then you're letting them go for violating your policy. It has nothing to do with their condition or their the accommodation to their job that they modified. However, I will tell you, if it's not an essential function of the employee's job to be at work on time, then you would need to consider an accommodation as to the time they report, if it has been verified, as we discussed, and that's a restriction that the doctor says we should analyze. All right, I think that's it for the questions. There's 3 more. Last question. Besides, I got to go breathe and have some water. This has been a lot of fun, though. So HR should be handling FMLA and ADA and not asking the direct supervisor to be involved in the processing. And the supervisor just needs to know they're not going to be at work for X amount of time, correct? And that is what I would say is yes. The supervisor will usually hear the situation first that should then bring to HR. HR will deal with the FMLA certification or the ADA medical documentation bit. And when all of that has been established, if we are dealing with accommodating a specific job rather than leave, then we're getting back in touch with the supervisor and we're saying the employee needs to be accommodated. These are the restrictions. Let's talk about what this job requires. And that's when we get back with the employee, the supervisor, and the HR, and we work out some reasonable accommodations. You're, as the HR, driving that conversation, and you're telling the supervisor if there's anything you need to say other than, listening and saying, yes, we can do that. Maybe we could try this. Anything other than that needs to be out of the presence of the employee and just with you later. You drive it and then you document it and everybody signs it. If it's leave, the supervisor does not need to be involved. In that scenario, we then go to the supervisor and say the employee has been granted FMLA leave for this block of time. If no need, please don't communicate with the employee. If the employee contacts you, don't ask them how they're doing, and when they're expected back, because under the FMLA, you're not allowed to do that. If they call and say, hey, you can say, hey, miss you. Hope everything's going well, but be careful with your communications. Under the ADA, same sort of thing. You just tell them how long they're out for and that you're going to keep them posted. All right, I think that's it. I appreciate everybody. We've still got some attendees on. Oh, if you shoot me, anonymous attendee, I'm going to go ahead and jump off. If you shoot me an email, I will answer that question. My email is at the last slide on this, and I know that Brittany will send it. So I appreciate everybody staying on. I appreciate all of the questions. It's a lot of fun. I see I have 25 more messages, but I think most of these are just thank yous and such. I'm glad to talk to anybody offline. Everybody have a great day, and thanks for coming. Oh, and don't forget, Brittany, Brittany, slide to the very last slide. Don't forget, come next month because Matt McLean is a guest presenter and he's going to talk to us about the Secure Act, which has a lot of rules that are in place for employers. And then May 25, I'm going to be talking about what impact it is on employers that the occur of emergency is officially declared over. Perry's going to give you a legal update in June. We'll have no webinar in July, and then we'll be back in August with Demetrius. So be sure to come next month, May and June. Have a great day, everybody.
Thanks for joining this webinar presented by Haynsworth Sinkler Boyd. To learn more about the firm and its services, visit hsblawfirm.com.